if or when James Comey beats the charges that the Trump administration has brought against him, he may have some recourse against the United States government, against Donald Trump. He may go after them for what's called malicious prosecution in civil court. And we're going to talk about that today, and we're going to cover what his recourse may be, what the challenges are, but what his recourse may be for what Donald Trump is doing to James Comey. I'm Shant Karnikian. That's Brian Kabateck. This is Civil Action on the Legal AF Network. We're a couple of lawyers and litigators working throughout the country, based in California. We're going to pick apart today James Comey's potential malicious prosecution case that he can bring against the Trump administration. Brian, why don't you explain to us what malicious prosecution is and how someone pursues a claim for that?
Yeah, a good place to start is to explain that malicious prosecution is very difficult to prove. However, this may be one of the examples. So what you're basically saying in malicious prosecution is that you didn't prosecute me. You didn't go after me because anything I did was actually illegal or wrong, but you did it for an improper purpose. So basically the elements of malicious prosecution, and see if this rings true as I'm going through it, is initiation of criminal proceedings. So you have to have started proceedings against somebody and saying that they engaged in a crime.
Check.
Which means you actually do it. Lack of probable cause, which basically means there was no reasonable grounds to believe the defendant was ever guilty in the first place. We'll talk about that. Malice, which is the prosecution was motivated by an improper purpose, such as bad faith, vindictiveness, or intent to harm rather than legitimate pursuit of justice. Okay.
Check. I'd say check.
Favorable termination. The case has to be thrown out, which I'm going to predict right now. This thing is a very short shelf life, and we can talk about that a little bit. And then ultimately that the defendant suffered harm. So I just want to focus on that last point before we get back into it. And I want to remind people that being prosecuted by the United States of America is incredibly harmful. Now, the vast majority of people that are prosecuted probably did something wrong, not all of them. And, there's terrible things that go on and people get prosecuted all the time. But in a case like this, where there is no legitimate reason for prosecuting them, the person has to go hire lawyers. They have to pay hundreds and hundreds of thousands of dollars in legal fees. They ultimately suffer harm to their reputation. They suffer harm to themselves, not to mention undoubtedly sleepless nights where you're sitting there saying, yeah, this is just terrible. Look what's happening to me. The government of the United States is coming after me. The weight of the government of 340 million people are coming after me. So
I'd say that last element, that fifth element of harm, I think it's a low bar, but it's very serious. I think I'd agree. Yeah, it's horrible.
Right. So where do you want to go from here, Sean? Do you want to talk at all about, for a minute, about why these charges are bullshit?
Sure. Yeah. We don't have to do a deep dive into the facts. I think others on the channel and in the general media have covered this, but let's talk about why it's sort of.
And we'll cover it in the future too, as things that come out. But basically it involves two statements that he actually didn't make to Congress. And what I mean by that is, one of the things people have to understand is that when you're cross-examining someone in real court, not in Congress, but in real court, a lot of times we ask what are called leading questions. Isn't it true, Mr. Karnikian, that the light was red when you went through it? And then you answer that, right?
Yeah.
So what in Congress is even more showcase, because what you're asking are, senators give, and here you've got Ted Cruz and you have Lindsey Graham. And both of them were asking, leading questions that had a lot of wind up. They didn't have their facts right in these questions, which are all critical, right? Right. Because in order to establish that you engage in perjury, first of all, you have to not just make an affirmative yes or no, but you actually have to really adopt the statement. So if I asked you, Sean, was the light green when you went through it? And you said, I think so, maybe. You're never going to get someone for perjury for that. If you said, absolutely, the light was red, I know the light was red, and then I could prove that you knew the light was green, then yeah, that might be
right. Perjury. Like you have a prior recording of me saying that the light was green, but when I'm testifying, I say, oh no, unequivocally, I know that the light was red. Yeah, that's perjury when it's like a full blown lie. Because there's degrees to this, right? And I agree when you see that cross examination in Congress, you're watching people get up there and talk on CNN, and they have like a 2-minute wind up, and they go, "Now isn't that true?" It's grandstanding all of the time, a lot of the time. So yeah, I think that's right.
Right. And so, I mean, like I said, we're not going to do a deep dive into this. I've looked at it. My own professional opinion is they don't have a case. Obviously, the former U.S. Attorney for the Eastern District of Virginia agreed there wasn't a case because he resigned because he was told to prosecute it anyways. And that kind of nicely takes a shunt to where, talk a little bit about the vindictiveness element in malicious prosecution.
Sure.
Present here.
Yeah. So the first element is they brought the charge. We got that. Second element was lack of probable cause. And I think Brian just talked about it. And just one comment on that. The fact that the prior U.S. attorney didn't want to pursue it, I think really helps establish the lack of probable cause. You had an experienced government lawyer prosecutor that didn't want to pursue it. I think that will help establish lack of probable cause. Now,
plus apparently other attorneys in the U.S. Attorney's Office, civil service employees, these are not political appointees, who sat there and said, you can't do this. You can't bring this case.
Yeah.
I mean, one thing I'll say about the U.S. attorney, and someone's going to disagree undoubtedly because they've seen bad cases brought, but for the most part, the U.S. attorneys across the country have a nasty habit of only pursuing cases that they have a 95% chance of conviction.
Right. Because it's good for their reputation, right? So, yeah. So for this guy to not pursue it, it's pretty telling. But okay, the vindictiveness component of it, the malice, malicious prosecution, I think this is a big portion of it. It's, I think, the crux of the case. If he brought a malicious prosecution case, you have to show that it was done in retribution and for improper purpose, improper motivation. And I think Trump cannot help himself. And he just, every day that goes by, he sits there and proves this, posting on Truth Social or whatever his stupid platform is about how, James Comey is one of the worst things that's happened to the United States. He's despicable. His, the post that he made, which appeared to be a private communication to Pam Bondi, where he said, we really got to do something in Virginia. We look really bad. We really got to go after these guys. This element, which is oftentimes the hardest element to prove malice. I think in this case will be one of the easiest elements to prove because Trump cannot shut the hell up, and he just keeps talking about this.
I apologize for interrupting, but I want to highlight what you're saying. First of all, apparently there's a memo that was drafted by career prosecutors saying there's no probable cause. No probable cause. So let me just be very clear. That's different than we don't think we can win the case, but there's probable cause. Here they're saying there's no probable cause. We just can't bring this case in the first place.
Can't bring the case. Not we can't win the case. We can't bring the case. Yeah.
Right. That's right. The former U.S. attorney resigns over this. Trump is on Truth Social saying you got to move now. And that's one of the interesting issues here, Shant, is that the statute of limitations is going to run at the end of September. So that was one of the things. He's directing Pam Bondi to move now. So you got to do it. Then he hand appoints a completely unqualified, in my humble opinion, U.S. attorney, a former third runner-up for Miss Colorado. And so you've got all the makings here of there's no real case, but we want to.
But even after they bring the charges, even after they indict him, he still can't shut the hell up about it, and he keeps yapping about it. I think, I'm sure there's better malicious prosecution cases out there, but in terms of the malice component, this is super strong. The malice component of it.
He called Comey a dirty cop. He called him a crook for years. He blamed him for the Russian probe. I mean, as you look at this, so look, it's not a slam dunk. There's something called sovereign immunity. The United States Supreme Court's decision in the Trump case about his own immunity as president, his presidential acts, all of that is a bar to this. But I've got to say, this looks to me, in my humble opinion, as one of the best malicious prosecution cases I've ever seen. And it'll only get better if the federal judge throws the case out in one of the first appearances when they're trying to establish if there was even basis for this. And that's the motion they'll bring.
Right. Well, let's not forget one of the other kind of final components of this is favorable termination. The case results in a favorable ending for the defendant, for James Comey here. Whether it's acquittal, dismissal, the charges just being voluntarily dropped. We'll see. And that's a spectrum too. It's not black or white, but that's a spectrum. We'll see. As Brian said, if it gets dropped early on, there's a better argument for favorable termination. It also increases the malice component, also increases the lack of probable cause component of it. But even further down the road, maybe through some motion or even an acquittal if it does go to trial. All of those can be favorable termination. We'll keep up with this. We'll see how it shakes out.
I want to add one more thing before we close out, Sean. I really do this before we close out. I want to add one more thing, which is when you're picking a jury, anybody who supports Trump is going to be disqualified from this jury. I mean, I can't imagine, because Trump himself has talked extensively about the prosecution, how important it is, how it's important. So they're going to end up, if this case even gets to a jury, which I highly doubt, they're going to end up with a jury with a bunch of people who don't support Trump. And that right there is going to doom the case in front of the jury if it even gets up for it. So that's my final thought on it.
Yeah.
I apologize for interrupting you, but let's move on.
Yeah. Well, no, I was just going to kind of wrap this up and say, we'll see, how this shakes out. I guarantee you Trump won't stop talking about this, and he'll make the case even more difficult and make James Comey's subsequent malicious prosecution case even stronger. We'll see if James Comey pursues that. I have no idea whether he would pursue it. I certainly would if I was in his position. Because, as challenging as it is, I think it would be a righteous case against Trump. I mean, somebody needs to punch back, and that's one way you can do it. So we'll keep following this. We'll see how it turns out. We'll see if it gets resolved favorably for Comey, and we'll keep you posted on it. I'm Shant Karnikian. That's Brian Kabateck. If you like this content, remember to hit that subscribe button, hit that like button, share with us your comments. We love hearing your feedback. Reach out to us if you have any questions. If you have a case or something you want to talk to us about, you can reach out to us as well. Thanks for tuning in. We'll see you on the next one.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.